Good evening, all. This is Dhananjaya Padmanabhachar from Karnataka Home Buyers Forum. A heartily welcome to all the viewers on social media. A heartily welcome to all the participants on Zoom who connected on a Sunday evening. I know everybody is busy with their personal life, but today all of you have joined a live session and the Zoom session to discuss one of the important topic that is creating a lot of confusions among the home buyers community in Karnataka, especially because of multiple acts, because of multiple confusions that exist in the society in the name of apartment association. So we are going to have a very detailed discussion today on the topic apartment association, what it is and how association can be formed, what are the different acts that prevailing in Karnataka, and what is the correct act that will help us to get us the legal rights, and some of the case studies that exist in the society. And also we will bring up to the speed to all the viewers on this channel about the High Court writ petition that is going on in the court of law. We may not discuss in detail about the court case because the case hearing is going on, and until unless the verdict comes, it's not good to discuss more detail about the case. But we will discuss about the subject, which is apartment association, which is creating a lot of confusions in the society. So with that welcome note, I wanted to welcome two important eminent guests today, Mr. Commander Surendra LS and Ameya. Heartily welcome to both of you, sir, on this platform. And I will formally introduce both of you through our introduction slide. Thanks a lot to both of you. Request both of you to be online and have your video on, sir. I will move to the gallery mode.
Thank you, Dhananjay.
Thanks a lot, Ameya, sir. Thank you, Commander, sir, and Chitra ma'am, and everyone who was on the call. Yeah. So I think with that note, every program will start with, a welcome note and along with a prayer to the God. And also in this platform, we wanted to remember all the gods from all the, varieties of people that we are on the call. And also, I wanted to play one important video since we are, this is an activist group and this is a, selfless services group from under Karnataka Home Buyers Forum. I wanted to show one small video about how apartment owners, flat owners, and the home buyers of Karnataka are undergoing a pain under the failure of RERA in Karnataka. So with that note, we will start off with welcome video for all of you. Please have a seat and then watch. Please let me know if it is visible. It's not it.
No, not yet.
Okay. Is the screen visible?
Yes.
Okay.
ಏನು ಫುಲ್
ಯಾರು ಯೂಟ್ಯೂಬ್ ಎಲ್ಲ ಬರ್ತಿದೆ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದು
ಇದು
Dhananjay, I am not able to see anything. My screen is showing as safe driving. Your microphone is muted. Your video is stopped.
ಯಾಕಿರದ ಇದು ಮೈನಿಮೈಸ್ ಮಾಡು
ನ್ಯಾಯ
staying in Showbox.
ಒಬ್ಬರನೊಬ್ಬರು ದೋಚಿದರೇನು, ಸುಲಿಗೆಯ ಮಾಡಿ ಬದುಕಿದರೇನು. ಒಬ್ಬರನೊಬ್ಬರು ದೋಚಿದರೇನು, ಸುಲಿಗೆಯ ಮಾಡಿ ಬದುಕಿದರೇನು. ಕೊಲೆಯನ್ನೇ ಮಾಡಿದರೇನು, ಅನ್ಯಾಯ ಮಾಡಿದರೇನು. ಹಾಯಾಗಿ ಬಾಳೋಕೆ ದಾರಿ ಉಂಟು. ಸಾಕ್ಷಿಯು ದೊರಕದ ಜಾಣ್ಮೆಯ ತೋರುತ್ತ ಗೆಲುವ ಪಡೆದರೆ ಸಚ್ಚಾಳುತ್ತಿದೆ. ನ್ಯಾಯ ಎಲ್ಲಿದೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ. ಕಾಯಿದೆಯೆನ್ನುವರು, ಕೋರ್ಟಿದೆಯೆನ್ನುವರು, ವಾದವ ಮಾಡಿ ಗೆಲ್ಲಿಸುವೆಯೆನ್ನುವರು. ಕಾಯಿದೆಯೆನ್ನುವರು, ಕೋರ್ಟಿದೆಯೆನ್ನುವರು, ವಾದವ ಮಾಡಿ ಗೆಲ್ಲಿಸುವೆಯೆನ್ನುವರು. ಯಾರೇನು ಹೇಳಿದರೇನು, ಯಾರೇನು ಮಾಡಿದರೇನು. ನಾಯಂತೆ ಅಲೆಯೋದೆ ನಿನಗೆ ಗತಿ. ಮಾತಿನ ಮಲ್ಲರ ವಾದಕ್ಕೆ ಎಲ್ಲರ ಮನವೂ ಸೋತಿರೆ, ನಿಜವೂ ಸೊರಗಿರೆ. ನ್ಯಾಯ ಎಲ್ಲಿದೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ. ಇಬ್ಬರ ಗುರಿಯು ಒಂದೇ ಆದರೂ, ಹೇಡಿನ ಕಿಡಿಗಳ ಕಾರುತ್ತ ಇದ್ದರು. ಇಬ್ಬರ ಗುರಿಯು ಒಂದೇ ಆದರೂ, ಹೇಡಿನ ಕಿಡಿಗಳ ಕಾರುತ್ತ ಇದ್ದರು. ಸೋದರನ ದಾರಿಯ ಬೇರೆ, ಸೋದರಿಯ ಹಾದಿಯ ಬೇರೆ. ಒಂದಾಗಿ ಬಾಳೋದು ಕನಸಾಯಿತು. ತಾಯಿಯ ಕಂಬನಿ ಒರೆಸುವ ನೆಪದಲ್ಲಿ ರೋಷ ಬೆಳೆದರೆ, ಪ್ರೀತಿ ಸೋತರೆ. ನ್ಯಾಯ ಎಲ್ಲಿದೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ. ಎಲ್ಲಿದೆಯೋ ನ್ಯಾಯ, ಅಣ್ಣ ಎಲ್ಲಿದೆಯೋ ನ್ಯಾಯ. ಬಡವನು ನ್ಯಾಯವ ಕೇಳುವುದೇ ಅನ್ಯಾಯ. ನ್ಯಾಯ ಎಲ್ಲಿದೆ, ನ್ಯಾಯ ಎಲ್ಲಿದೆ.
Thanks a lot, viewers, for watching a very important video of how home buyers of Karnataka are getting home dhoka while they booked a flat and they're not getting the home on time. And another version of that is, even after getting a house or a flat, some of the important aspects of apartment owners' rights are not getting protected in Karnataka. For whatever reason that's happening in the state of Karnataka, home buyers, flat owners are suffering on a daily basis, and their protection of their fundamental rights on the home is not being taken care of in Karnataka. And that is one of the reasons why we are moving ahead from Karnataka Home Buyer Forum, taking this battle of home buyers to apartment owners and ensuring that some of the developments that we wanted to share across has been captured within this video. And then today we have an eminent personalities, Commander Surendra sir and Ameya Usgonkar is part of our discussions. And then it's my pleasure on behalf of Karnataka Home Buyers Forum, who are also part of the same forum. All of them are part of the same forum, coming together to fight. But in the interest of everyone to getting to know whom we are speaking to, it is important, and it's my pleasure to introduce Commander Surendra sir and Ameya Usgonkar into the platform so that people know whom they are speaking to. welcome to you, Commander sir and Ameya sir. Request Ameya sir to put your video on, and then I will run through a small presentation for the benefit of everyone to introduce Commander sir and Ameya sir. Please let me know once the PPT is visible. Is the PPT visible?
Yes.
Yes.
So this is Dhananjaya. This is a small introduction. I will not say much. I think you must have already got the glimpse of it. So let me take this opportunity to introduce Commander sir, who's a retired Indian Navy officer, and Sri Ameya Usgankar, who is an IT leader and home buyer association expert. So just want to give a glimpse of it, what Mr. Commander L.S. Surendra sir has done for the society in India. He is an NDA cadet 1968 batch, joined the Indian Navy in 1971 and took a voluntary retirement from the Navy in November 1991 after serving 21 years for Indian, and served on warships INS Vikrant, INS Basin, INS Kuta, and Amini, and INS Bedi, specialized in anti-submarine warfare and mine countermeasure warfare. Commanded warships INS Puri and Bhavangar and INS Pondicherry. Served offshore as an instructor at NDA Pune Naval Academy, Kochi, and as a staff officer at Headquarters Southern Naval Command, Kochi, and as a member of selection board at South Bangalore. This is a small introduction of our Commander L.S. Surendra sir, and a big salute on behalf of Home Buyers Forum and also on behalf of everyone in the society who fought for the country in Indian Navy and now fighting for the home buyers community with a due respect. Heartily welcome to you, Commander sir.
Thank you, Dhananjay.
Yeah, thanks a lot, sir. Thanks a lot.
For the lofty words that you have spoken about me. Let me share with you and our co-owners and members of Karnataka Home Buyers Forum that today happens to be the Navy Day, which we celebrate annually, the 4th December. And it was on this day of 4th December 1971, where the Navy gave a fitting blow to the Pakistan Navy in sinking number of ships and damaging the port of Karachi. So with that as the background, Navy celebrates its victory over our adversary on the 4th of December as a Navy Day. And well, you have chosen this day, and it gives me great pleasure that I have been able to safeguard the nation from adversaries. But now it's unfortunate that I have to pick up, not literally, but figuratively, pick up a sword and fight with my own people to establish that the right of each individual is to be respected. Thank you, Dhananjay. We can proceed ahead.
Thanks a lot, Commander sir. I think you take a great respect for the entire Indian Navy who are protecting us, and it's our pleasure that we chosen this day, and unknowingly we chosen this day, but knowingly it has become a Navy Day. And on that Navy Day itself, we have a Navy retired Navy personnel officer with us. Is really blessings for all the home buyers, and very interestingly, anti-submarine warfare expert and a very expert on acts as well. That's the fundamental difference that a Navy person carries. An army person or a Navy person or an Air Force person, a soldier, always a soldier for the lifetime. That quote always holds good with your name, sir. Thanks a lot. And another very interesting personality, Mr. Ameya Usgankar. He's one of the IT leader in Bangalore, working for a multinational company and home buyer association experts. He is an master's in IIT Mumbai and home buyer expert, and who himself experienced a lot of differences in the acts, and then undergoing of battle with the builders in terms of experiencing, and that experience he is trying to evangelize and then passing it to home buyers. So this is an experienced platform with the experts on the board today. Yeah. So with the
thank you, Dhananjay.
Yeah, thanks a lot, Ameya sir, and a hearty welcome to you to the show, and be part of the panel discussions today. Yeah. So with that note, as a mode of operandi, I will try to use English as a common language, but in between, I will be using our most spoken language Hindi, as well as trying to see if I can refer to some of the Kannada wordings as well, so that we keep a language agnostic discussion in this, so that everybody understands and then everybody can relate to it. Yeah. Okay, so what is an apartment association, right? Everybody is, thinking about purchasing a flat, purchasing an apartment. And what is I think everybody know what is a flat, what is an apartment, what is an association. So apartment owners association is an association where all the owners of the apartment are the members, and the association maintains the facilities or the amenities available within the apartment. Fundamental definition. So I have not kept the very, very complicated definition of what is an apartment association, which is very straightforward understood. An apartment association is an association of persons, a association of owners in the apartment to upkeep the apartment facilities in the apartment. So why it is required? So if you have a 30-40 independent site, you build your own house. But if you are building a complex apartment, if you are building a multi-storied building where a lot of people, a lot of owners, neighbors stay together, it is important that we need an association. But why? The question arises, why? To take care of the maintenance of the common areas. In a large projects or any project in that matter, there are common areas that need to be taken care, right? So if you have your own site, you will take care of yourself. But if it is a common area, then it has to be taken care. And then to work for the welfare of the residents and to conduct events or awareness programs, most importantly, to protect the rights of the apartment owners. I think that's one of the important topic of the day today, how to protect the rights of the apartment owners and to defend legal action raised against the association. It's very important. And if you want to be a legal, if you want to represent the association, it has to be a registered body. So we'll discuss about this in detail with our experts. So is it necessary for an apartment to be association to be registered? The answer is yes, because the court says, right? And it is very important as a citizen of this country, we follow the court order. There was a case in National Consumer Court which declared that association of owners need to be a registered body so that it can represent the owners of the association, right? Or it can fight against the builders in the interest of the common interest of the apartment owners. So it's very important. Please make a note of this. An apartment need to be registered as per the court directions, and as per, if you want to fight, it has to be a registered body. So what are the advantages of a registered association? The funds collected is more transparent in nature. The association will be more able to take against the defaulting residents as well, because sometimes, you will have a residents who doesn't pay the maintenance, and if you are a registered body, you can take a legal course of action and other important contributions as well, right? And registration can take convenience deed. Very, very important. Third point, a registered association can only take a convenience deed, called a convenience deed or deemed, whatever you call it as, from the developers to take control of the project land title. Very, very important. Third point is very important. If it is not a registered body, you cannot take a convenience deed. So how association can be registered? How association can be formed? Here, there are 4 ways which was existent. Let me talk about the past first. There are 4 acts that was existed. Karnataka Societies Registrations Act 1960, which we call it as KSRA 1960. Karnataka Apartment Ownership Act 1972, KOFA 1972. There is some debate and discussion that will happen on these aspects. And Karnataka Co-Operative Societies Act 1959. Companies Act 2007. So there are 4 ways association was getting registered earlier, and today there are some regulations that has come. I will walk you through. I request everyone to be on mute. Vishweshwar Upin, please go on mute. Vishweshwar Upin, request you to go on mute. Okay, so these are the 4 important aspects that we have look at it as an apartment association, registration perspectives. I wanted to give a
DJ, I think you can put him on mute.
DJ, if somebody can put him on mute, that will help.
Yeah, just a second. Okay, so it is very important that we refer some of the government order. The reason I said earlier, we were registering, or association was getting registered under 4 different acts. Whether we call it as well as a registered body or registration is a debate that we're going to have it today. But there were 4 provisions that existed earlier, and there are associations that exist today, which they declare it as an association, which they are registered as an association. So we'll discuss very in detail with our experts. So I want to refer some of the government orders for everyone's benefit. In 2018, there was an order passed by the Registrar of Cooperative Societies where they declared that any association cannot be registered, apartment association, owners association cannot be registered under 1950. This order is passed in 2018. Please make a note of it. And in 2019, when one of the home buyer flat owner complained about the association in the Register of Cooperative Societies, the Register of Cooperative Societies declined to address the issues, saying that they don't have a jurisdiction to resolve the dispute between the parties. And this association was declared under KOA 1972. So in 2018, Register of Cooperative Societies passed an order, you cannot register an association under KSRA 1960. And in 2019, a verdict came where the Register of Cooperative Societies said, I don't have a jurisdiction to resolve the dispute between the parties. These are all the live document. These are all the government orders that we are referring to, and we are showing the screenshot live. And this order came in 2019. Very important. KOA Association, where Register of Cooperative Society declared to address the issue because it doesn't come under their jurisdiction. Gangadhar, can you please go on mute, sir? Okay, and another important aspect, there are 2 more orders I want to. So another important order is 2020, where one of the activists, RTI activists, filed a complaint, filed an RTI information to seek from the Register of Cooperative Societies. Okay, guys, can you please go on mute here?
DJ, better to make somebody moderator who can.
Yeah. Amaya sir, can you please moderate?
I can do, yes.
Yeah.
You need to pass the control to me.
Yeah, I have passed the control. Just check whether you got admin rights. I made you as a co-host, yeah?
Dhananjay, I have a small request.
Yeah.
Those who are not very serious in, participating in the meeting, and, I don't know, for whatever reasons, they are not attentive and, things like that, they may be requested to, not interrupt by keeping their, mic on, something, whatever is, each house has got their own problem.
Yeah,
Then
exactly.
talking, etc. It only diverts our attention, distracts our attention. There are so many of us who have joined together to make it a worthwhile meeting.
Yeah, makes
Right?
sense, sir.
No,
Makes sense.
I
I
mean,
request
politely
everyone
we
to
can-
be unmute. Yeah. I request
So we
once
can
again
politely
everyone
tell
to
them
unmute.
that, look, this is what it is. Please
Yeah.
be a little more serious.
Okay. Amay sir, you got the admin rights?
Yes.
Okay, good. So another important government order reference, I want to go back once again. 2018, Register of Cooperative Society passed an order where they have stopped registration of apartment owners association under 1960 Act. And in 2019, an association which was claimed to be registered, claimed to be doing the operations of the apartment under KOA 1972, registrar said, I don't have a jurisdiction. So 1960, no association. 1972, they're saying, I cannot address your issue because it is not under my jurisdiction. In 2020, one of the activists filed RTI where they asked whether the sub-registrar is a competent authority to register an apartment association. The answer is no. So a KOA association sub-registrar does not have an authority to register apartment association. And a Register of Cooperative Society says, I don't have a jurisdiction. So KOA association, what it is is a question. So please hold on this question. I will answer to it in the next subsequent section. And if you look at the date in 2022, another RTA has been filed on RERA saying that, can you please pass us the Gazette notification where a deed of declaration submitted along with KOA can be declared an association. The RERA says, no, they don't have anything, any Gazette notification from the government of Karnataka. So with all this context, an apartment association under KOA is a legal entity, where it is a body which can be called as a registered association. Very good question, but the answer the court of law has to say to us. So this is a court case that I was referring to. It was filed by Bangalore City Flat Owners Welfare Association. The case number is writ petition 511 of 2021, where they're discussing about this. And since the court of law is addressing this, you can look at the daily order also has been attached in this. 28/9/2022, there was a daily order being passed in the court of law. In 14/7, there was one hearing. 25/5, there was one hearing. It's still a pending case where the verdict has not come in. So very, very important. High Court of Karnataka still not passed an order on this as per the current data available in the online High Court of Karnataka website that I just now downloaded and passing on in this platform. So this case is still pending. The verdict has not been passed. Okay, since the verdict is still not passed, we will not comment on this particular section. Let the court of law decide. So what is the debate topic? What is the debate topic for today? What are the cases that we are referring to? Association registered under KSRA in 1960. Association declared under KOA in 1972. Association registered under KCSA in 1959. Association registered under Companies Act in 2013. What is the right act? What is the right act? What is the right way of registering an association is the topic of the day. And once again, I wanted to declare that this is a platform of open expression, and the expression being expressed in this platform is the experience and the knowledge of the experts and the individuals that they have in their experience and whatever they have experienced in the platform and their struggle with the system. And this is only on a knowledge-based discussion, not a conclusory discussion. Please make a note of it. A disclaimer we wanted to make on this platform. This is a discussion that home buyers, flat owners wanted to have this at the right time so that the message pass on to the respective stakeholders. And what are the different acts? Karnataka Society Registration Act, Karnataka Apartment Ownership Act, Karnataka Co-Operative Societies Act, Companies Act. These are the 4 reference documents. And let the group discussion begin. So I will open up the platform, sir. I will open up the platform in each of the cases. Let's start with our commander, Surendra, sir. A fundamental question to you, Commander Surendra, sir. What is the right act? What is the right act? You're on mute, sir.
Yeah, I've unmuted. The right act today, as per what law is available to us, is to register an apartment association either under the Karnataka Co-Operative Society Act 1959 or under the Companies Act.
Okay, excellent. So as per the regular government guidelines, as per RERA, it is the Cooperative Society Act and as well as Companies Act. Why?
I would like to put slight historical context here.
Yeah, please go ahead, sir.
Probably, so the 4 acts that you have pointed out, they are correct. Another most important thing which is often ignored intentionally by builders, and this is before RERA came into picture, is the act of KOFA, that is Karnataka Ownership Flats Act 1972. It is this statutory regulatory act which puts lot of accountability, liability on the promoter. No builder will tell you about KOFA 1972 because it is their nightmare. They hate it. After all, who wants to be controlled by a regulatory act? Just as you saw when RERA came into picture, there was so much of vociferous, vehement cases filed across different courts, and Supreme Court in every such instance has clearly called out and put the accountability and the liability together with the defaults and the penalties to be imposed on the promoter as part of failure to adhere to RERA. And if you anytime go do a Google of Karnataka Ownership Flat Act, it's a 3 or 4 page document from India, I think indiacode.nic.in, that is the website, and check the corresponding summary of RERA. You will see that the two acts are very much in sync. Exact wordings also are there. Exact penalties also are called out. Exact compensations are also called out. Lots of these things are called out. So both these acts, KOFA and RERA, they prescribe either Companies Act, as Commander said, or the Cooperative Societies Act, as again Commander said. So this is the historical background which everybody has to be aware that there is a regulatory act called KOFA, Karnataka Ownership Flats Act, and that act regulates the promoter.
Excellent.
If your project is pre-RERA, if there is no OC, if you have been sold for say some UDS, please check if your name really appears in the encumbrance certificate of the project land. If it is not there, you should be concerned.
Excellent. I think very good important point that you brought up, Ameya sir. Pre-RERA, KOFA is applicable. Post-RERA, RERA is applicable. So I think there are a lot of debate. I think it's an open platform. Everybody can ask questions. So one of the important question I wanted to ask in the interest of everyone's, I think this is going on everyone's mind. So you're saying before RERA came, KOFA was applicable, and after RERA came, RERA is applicable. Is that statement right, sir?
Pretty much.
Okay. So let's come to pre-RERA. Since we are a transformation, we call it as a transformation generation. So in the acts also, we are undergoing pre-RERA projects and post-RERA projects. So let us take a project example where we have an apartment, around 70-80 flats are there, and it is not under RERA. The construction happened in 2006-2007 during a time frame. And association is being formed under KSRA 1960. Okay. And there is no mention of Apartment Ownership Act. There is no mention of Cooperative Societies Act. The builder just conveyed the UDS and the flat, and the government took the stamp duty and registered the flat, and EC of a flat your name reflects, whereas nobody bothered to check EC of the project land. So there's important thing I think many home buyers need to understand. EC of a flat is different and encumbrance certificate of a project land is different. So Ameya sir, I want to pass on this topic to you to explain to all the viewers. So the fundamental difference between encumbrance certificate of a flat and the difference of encumbrance certificate of a land.
Sure. So first of all, what is encumbrance certificate? So as the name states, encumbrance means owner has kind of entered into certain transactions with some purchasers as part of say the land development or as part of sale or something of that type. That means the land title is encumbered. It is no more the exclusive title for the project holder. Now, when this happens, and when you kind of get your apartment, you would obviously expect, that, hey, I have done registration at sub-registrar's office. I've got my UDS. So my name has to be there in the encumbrance certificate. Unfortunately, this is not the case. Your sale deed is not equal to conveyance or encumbrance on the project land. This is because apartment ownership consists of 2 or 3 major parts. First is your apartment. This is something which becomes yours as part of execution of sale deed itself. Nobody else can take it from you. Second is the ownership of the common areas. All the owners collectively own the common areas. And third, and the most important, is the title of the actual project land. If builder says that he or she or it, whoever it is, has kind of, sold the apartments and gone, why is it that the association is left unregistered? Think over this. Why is it that your name as an apartment owner does not get reflected in the encumbrance certificate of the project land? Simply because an apartment is something which is floating in air. It is not attached to the ground. And therefore, the Transfer of Properties Act does not recognize an apartment as something which can be registered. So what do the builders do? They do something known as selling of UDS, undivided share of land. Now, let me tell you one thing. There is no term called undivided share of land, either in the Transfer of Properties Act or the Registration Act or the KOFA Act or the KAOA Act or the Societies Registration Act or the Cooperative Societies Act or the RERA Act. None of these has any definition of UDS, but KAOA does speak about UDI, that is interest, undivided interest. And why does it spell it out? Simply because as if the interest is known according to your built up area, the maintenance is easy to be determined. So let's say, one say a 3-bedroom apartment has got undivided interest of, let us say, some 100 square feet. And another, say, 5-bedroom apartment has got, say, some 200 square feet as its undivided interest. So which means the bigger SBA, the bigger super built up area apartment will pay higher maintenance than the 3-bedroom apartment. But as far as the ownership is concerned, ownership, that means the title to the project land is concerned, the sale deed has no correlation. It is simply the fulfillment of promises that were done by the builder when he or she signed the agreement of sale, AFS as we call it, with you at the time of construction. And if you look into KOFA or RERA, both the acts very clearly state that the builder must register the sale agreement. Majority of the times you will see builder saying, I have paid the duty, so it is all as good as registered. No, you are being taken for a ride. Stamp duty payment does not register your agreement for sale. Stamp duty payment simply says that, or as the sub-registrars call it, it's a franking which is done there. The franking essentially says that, this document is legally valid. It cannot be challenged in any court. Tomorrow, if you have a dispute with a builder, there was a recent Supreme Court judgment wherein it said that unregistered sale agreements will not be acceptable in any court of law. Which means all your rights, all your claims about the builder or about some deficiency of service,
Sir, I think your network is disturbing. Hello? Is the same issue, Commander sir? You're able to hear them?
No, it is getting interrupted.
Amey sir, I think your network is an issue. Yeah, I think he got disconnected. You're on mute, sir.
Am I audible? I think I just disconnected in between.
Yeah.
Okay, so make sure at least for RERA registered projects, make sure that you go to sub-registrar, you insist on the registration of your agreement for sale. That is the most important crucial document, most important, very, very crucial document. And the registration of AFS in sub-registrar office will guarantee your name on the land title. It will put your name as one of the, as one of the parties, and thus establish your lien, LIEN, on the property. When you do that, builder is automatically stopped from doing activities like change of plans, registration of DOD without your consent, introduction of new towers, change of any common amenities. Everything is stopped automatically for the builder. And that is because municipality, before approving the plan, they will say, get the encumbrance certificate. And if they see more than one name on the encumbrance certificate, they will ask for consent from that particular purchaser or that particular person. KOFA also said the same thing. Unfortunately, our government did not do its implementation. In course of time, it was just brushed under the carpet. And in doing so, we, the home buyers, lost. Completely, we lost it.
Very good point. I think, Kamaya sir, you are bringing up the sale of agreement, AFS agreement for sale need to be registered. I think it's, new home buyers who are looking at it can look at it. But one question I have, sir, if let us take a pre-RERA project. So if it is a pre-RERA, the registration of the sale deed is already done. So what the flat owner should do?
Okay, so the other way to kind of, get title or get yourself secured or get your project land secured is to, so this will happen for, majority of those projects where AFS was not registered. And so the title is still in the name of the builder. If you have still missed the first part, you can still get something that you lost in the second part as follows. Make your association registered. And when you make your association registered, it has to be a juristic body. Supreme Court, in the judgment of in that famous judgment of Ilachi Devi, in that Ilachi Devi judgment, Supreme Court clearly clarified that only two juristic bodies can take title ownership of the land. First is cooperative society and second is company. So those of you, including me, who have their sale, who have their AFS unregistered, the first thing that we need to do is get your association registered as a cooperative society. And once you do that, then you file for a claim in the Registrar of Cooperative Societies for the deed of conveyance in favor of this registered body. Deed of conveyance essentially means transfer of title of the project land in favor of the new purchaser. And as all of you know, that all the owners collectively own the entire project land. They have their share collectively to the project land. This is something which is now the need of the hour. It has to be done. Even the RERA Act, I think it is section 11, subsection 4 and another subsection E or F, one of those, they clearly say that the builder has to do the deed of conveyance in favor of the registered association. Until then, it is the builder's responsibility, accountability, and liability to maintain the project at its own cost. The builder cannot charge you.
Very good point. Very good point, sir. I think the point is very clear. Any project where AFS is not registered, the only way to protect the interest of the home buyers is to ensure we have an cooperative society registered association or a company act registered association and request the transfer of property. Otherwise, home buyers, please remember, if it is not a registered agreement of sale, agreement for sale, then the land rights is not with the home buyers. Very, very clear message that Amaya sir wanted to pass on. I think this is where the most of the home buyers, Amaya sir, are confused with the sale deed, where EC talks about UDS mentioning some 200, 300 square feet of land in the flat UDS, which is written there in the EC, getting confused with the project land encumbrance. So that's where the confusion is. I think your messaging is very clear and loud, and a very good strong message to the home buyers. Thanks a lot, Amaya sir. So I will pass on to Surendra sir, and I will take a break to Amaya sir. Sir, Surendra sir, the same question pass on to you. I think Amaya sir talked about pre-RERA, KOFA and stuff. So under RERA, so let us say that the AFS is not registered, right? And any new home buyer who is watching this video can definitely insist and make the builder to register the AFS if you are a new home buyer. Please remember, even the Karnataka government, I can share you one of the important link on this platform today, where the registrations of Department of Stamps and Registration also clearly say the same thing, whatever just now Amaya sir told. So in the interest of everyone, I'm sharing the screen, which is Karnataka Stamps and Registration. So I want to walk you through what it means, registration of instruments related to flats and apartment. I will share this link later, and this is a government site which talks about what are the cases to which the apartment as is applicable. The act applicable in case where owner or the owner signed the required declaration or registered the same as provided in the act. What is an apartment? Apartment is an independent dwelling unit having one or more rooms, and having a building with one or more stories providing access to place where common road. What is a building, and etc., right? So I want to go to the purchase of a flat. So what are the conditions to purchase a flat? A developer of flats must register an agreement before accepting advance of deposit. Such an advance deposit shall not exceed 20% of the agreed amount. And how ownership of flat can be acquired? A developer of a flat is required to transfer it to a registered association. Please make a note of this. Transfer it to the registered association, cooperative society, or a company of buyers of flats within a period of agreement. Please remember this very important statement which Amaya sir highlighted. Even the government of Karnataka is saying the same thing. He should also endeavor for the formation of such association, cooperative society, or a company within a prescribed period, right? And then ownership, it also talks about the KOFA here, okay? And registration is compulsory. A purchaser will not get ownership title to the flat without registration. Is it necessary to register transfer deeds executed in favor of cooperative society? It says yes, it has to be registered. How the right is transferred in the case of sale? The sale of flat apartment is as simple as another transaction. Purchaser acquires rights may be registered in sub-register office, and it should have undivided interest in land, carpet area, whatever, a proportionate share, carpet area of the apartment and common areas. Is it not possible to become owner of a flat apartment by purchasing only undivided share? The answer is not possible only by purchasing undivided share. What are the precautions to be taken while purchasing an apartment? So you need to ensure these are the important things. They're calling it as a precaution. The first is agreement to sell with the promoter should be compulsorily registered in sub-register office. Thereafter, sale deed also should be registered. Please make a note of this. All the new home buyers who have not done the registration in the sub-register office of agreement of sale, it has to be compulsorily registered. Those who are in the process of purchasing any flat, please ensure you register. Some of the home buyers are already got into this trap, but you guys don't do that. A permission of construction and sanction plan, everything need to be verified. So there's a list of questions that is, need to be gone through? Is it valid to get transfer of ownership of flat apartment through a transfer of share cooperative society without registered deed? It is not legally valid. Cooperative societies also allot a flat number in the name of Registration Act. Is it consistent of stamp duty? Yes, it is no, right? So very important, guys, please remember this question number 1. This, if you follow, most of our problems will be solved and the cheating of builders and the landowners will come to an end. Please insist on registration of AFS. Yes, sir.
Yeah. So now people must have noticed here, there is no mention of undivided share. People saw undivided interest, UDI.
Correct.
There is no mention of KAOA. There is only KOFA.
Exactly.
So why are builders saying everything about KAOA? What is it? It is something which is not meant for builders. Let me tell you, the KOFA has been exactly copied word by word from its, from the neighboring state, Maharashtra's MOFA, MOFA. Section by section, word by word, it was copied. And unfortunately, we, the people from Karnataka, forgot to catch up with the copy business. Copy business is always like that. If the main person makes a mistake, you will make a mistake. And then you will not know what to do. Herein, actually, in MOFA also, there was something wrong in the rules. In the case of Maharashtra Ownership Flats Act, that is MOFA, a wrong rule was introduced, which said that when the developer wishes to submit the property to the provisions of MAOA, the counterpart of KAOA in Maharashtra, the builder has to follow certain steps. We also copied, people of Karnataka also copied it into KAOA, into the KOFA rules. Later on, the people of Maharashtra understood their mistake and they rectified it by inserting section or by inserting a subsection 2 under section 10 of MOFA. Since we did not know what to do with it, we thought, the act is all right, everything all right. So we kind of forgot it. And it is this major, mistake. And I would say it's a blessing in disguise. It is this blessing in disguise which prohibits the builders of Karnataka to submit to KAOA. They cannot do it. They are just bound by the regulatory KOFA. There is no other act to which the builders can submit or builders can claim that, this is what they can do. So if any builder asks you that, the property has to be submitted under KAOA, please ask 2 or 3 important questions. Take a printout of KAOA first page or first 2-3 pages and ask the builder to spot words like developer, promoter, or builder in the entire act. There is no such word there. Second thing, there is no relief for any, defaults or disputes that may happen. Why is it so? It is because KAOA is meant for the apartment purchasers only. The apartment purchasers can submit to KAOA only when they are the owners, they are the title holders of the property. They become the title holders of the property when the builder transfers the title of ownership to their registered body, which is cooperative society. When will the cooperative society be created? Only if the builder follows KOFA. And the moment builder follows KOFA, he is bound by the regulatory act. He is accountable and responsible for the defaults and the penalties, which include even imprisonment. No builder will tell you this because they don't want to open their weak side. It is for us to be aware and to kind of take it to a closure in case we are aggrieved.
Excellent. Very good point, sir. I think very good point, Ameya sir. Surendra sir, I want to pass on the mic to you to stress upon post RERA. Let us take a case by case example. We have a RERA, we have a KOFA, and whatever applicable in KOFA, Ameya sir very well explained. So let us say take an example of a RERA registered project. And under RERA also, it has to be cooperative society to be formed. And as per my knowledge, the AFS is not getting registered. So in this situation, so what should the home buyers do?
See, as far as AFS registration is concerned, right? Those who are yet to take the step of, registering an an agreement, can insist on registering an agreement with the promoter. I will not use the word builder because promoter encompasses all of them, right? They should insist on that. But what has happened is now, Amaya has covered the subject in greater detail and in point wise. There are a few things which I would like to emphasize here is now this post RERA, pre RERA issue is very much right, but there is a slight amplification required here. Now, when RERA Act came into force, right, there were projects which had started earlier but had not been completed. Now, the word completed means that the project had not received the occupation certificate, right? So those projects were also mandatorily told to register under RERA and come under the purview of RERA. Though, of course, these projects were supposed to be under KOFA, because like what Amaya said, KOFA has been in existence since 72 from the time it has been enacted and has received the assent of the president. But rightly so, it has been put into the cupboard and closed, because no builder, no promoter wanted to make the home buyer aware of the regulatory act and what are his obligations and accountability. Right? RERA has received a little larger picture because it was debated very widely in the media and throughout the country. But still, builders circumvent these things because we are not watchful. I am also a victim of same thing. I have a project which was supposed to be pre-RERA, but since OC, as a matter of fact, even today OC is pending. OC is not to be seen anywhere. It has come under RERA, and my agreement is not registered. Exactly like what Amaya said, that in spite of having had some amount of exposure to this particular real estate dilemma which is going on, I was also fooled. Exactly like what Amaya put it across. I was shown the stamping of the stamp duty, right, and told that, sir, everything is being done. Sub-registrar office ka kam ho gaya hai. And I also accepted and kept quiet. It's only in the recent past that when I opened and saw that, yes, stamp duty has been paid, my agreement to sale has not been registered. So I do not have a legal agreement to sale. So when I asked the promoter, now that the project is come under RERA, why don't you correct it? No answer. And same tamasha going on, saying that no, we are this, we are that. Right? Now, in this context, Dhananjay, I would like to touch upon a few points of Karnataka Ownership Act 72, because a large number of our home buyers and their projects have been supposed to have gone under the Karnataka Apartment Ownership Act 72. Though, like what Amaya said, is that is the legal aspect of it, but practically what has happened and why are we made to understand that this is what it is, there is a little bit of information which is required. Now, sure, the need for Apartment Ownership Act 72 comes from the fact that an apartment, like rightly Amaya put it across, then that apartment is in virtual space. It is not attached to the ground. And the land on which your apartment is built, along with all the other facilities and common area, which is defined as common area in both KOFA as well as RERA and as well as KOA 72, is the total project land, which includes the land on which your apartment is standing. That is a tower, right? Is common area, right? Now, this common area is distributed among the owners in a form of undivided interest. Rightly, what Amaya said is right. There is no mention of undivided share in any act. It's an industry term, right? So basically what should happen is that you own your apartment that is the space between four walls that you have, and the land on which your complete project exists is co-owned with all other owners, and this is to be held in co-ownership. Right now, since the Transfer of Property Act, and because it's this UDI, it has no boundary, and since it does not have a boundary, right, as per Transfer of Property Act, right, it cannot be conveyed or a title cannot be transferred. To just put it in a simple words, I mean simple way, I would take an example. Is that if I have a pot of water which contains 100 glasses of water, 10 belong to me, 5 belongs to Ameya, 15 belongs to Dhananjay, etc., etc. Now, when you look at that pot of water, can you identify which 10 belongs to Surendra, which 15 belongs to Dhananjay? No, it cannot be done. So our land holding is like that. It has to be handled as the pot of water, that is total 100 glasses of water, and handled like that. So this is the concept of undivided this thing. So since that cannot be done, and since an immovable property only can be heritable and transferable, and apartment does not fall into that immovable property, there was a need to give this special status to apartment by bringing it under a specific act, for which this Karnataka Ownership Act 72 was enacted. You will see this specifically mentioned in the objective of the act, that this is only to property to make it heritable and transferable. Now, the dichotomy of this is that though it is imperative that an apartment built should be brought under the Act of 72, that is Apartment Ownership Act 72, to give it a status of immovable property, I do not know why our lawmakers made it an optional act. Now you will find in the state of Karnataka, some are under 72, some are not under 72. And this is again a creation of both the industry and the laxity of the government and the bureaucracy, that it has remained there. There is nothing stopped, there nothing has happened. Even apartments which are not under 72 Act are getting transferred by the sub-registrar. He is not asking any questions. So it's basically, it is an act which is useless. It has only created problems, but not safeguarded your safety. But okay, that apart. Now, those which have been supposed to have been under 72, builders use this as a tool to hoodwink the home buyers, saying that once the property is under this particular act, your association is registered, your property is transferred, your conveyance is done, everything is done, you need not do anything. Now, this is the state of affair in majority of the cases where Apartment Ownership Act 72 has been used.
Okay, excellent. Very good point that you brought up, sir. Under apartment which is declared as a apartment under 1972, even there the association need to be registered under Cooperative Societies Act and then ask for a transfer, because the AFS is not registered in majority of the apartments. So even whether it is 1972 or 1960, the Cooperative Society Act need to be formed by the apartment owners and ask for transfer of the property in the name of the association to protect the interest. Otherwise, the builder or an ex-landowner, whoever was the landowner of the project, will continue to be the landowner of the project for the lifetime. So very, very important point that each one of the home buyers need to understand, because AFS is not registered. Very good point, Surendra.
I would like to share one more important aspect to those home buyers who are facing the same issue of their apartment, the property has been conveyed under Karnataka Apartment Ownership Act 72, and the builder or the promoter and as well as the association insist that everything is honky-dory, right? But majority of the apartment complexes which have got submitted under the Apartment Ownership Act 72 have been done by the promoter, builder, whosoever it is. There again, who has been doing it? It is again, nobody is questioning, so anybody is doing it. Secondly, they have only done what is called the deed of declaration. Majority of those have not followed the steps thereafter. Right? There is a default by the government in following what is the law, and also there is a default by the promoter in following these steps. Most of the sale deeds, which subsequently the promoter has registered in favor of the purchaser, has been made as a sale deed, not as a deed of apartment. The Act says it should be made as a deed of apartment. It's a special deed, which is also a sale deed, but it is called a deed of apartment. It should contain a certain more data into that. But I have not come across anybody who has followed this process of deed of apartment. So, it's totally a hodgepodge, and there is no way that the promoter can say that the property, even if whatever, like what you mentioned earlier, the issue of the Karnataka Ownership Act 72 and its validity is in question, and it is in the court. Irrespective of what the court takes a decision, right? Then the next step is, has your property been submitted under the Act in the way it is mentioned in the Act, is the next question. So there also you will find that you do not hold a deed of apartment, right? Even if in a hypothetical case, even if, let us say, the court takes a slightly lenient view and then makes a little bit of compromise and says, okay, the Act can be, amended here, amended there, and made all right, right? Even then you will find that the steps in the Act have not been followed, right? So it will only lead you to further problems. Then two wrongs will not make it right. So that's an issue which I would request all our home buyers who find that their apartment has been submitted under the Karnataka Apartment Ownership Act 72 to go back and look at their conveyance deed of their apartment, whether it has been made as per the Act or it is just like, casual way of making a sale deed. I am one of those, right, who hold an apartment. My property is supposed to have been submitted, right? 1 second, Amaya. Submitted under 72 Act, but what I hold is a sale deed. There is no mention of DOD, nothing of that sort, right? So I'm sure, because I have checked with a couple of others and find that this is what it is. And please go back and check whether they have followed this or not. As far as the Apartment Ownership Act 72 is concerned, I would put it this way: it's a waste of time discussing that. It is nothing but, in what we call in Hindi, it is raddi. Where it finds is, it should be in the waste paper basket. It has no relevance, right? So, but however, since we have been made to go under that, if any of you have any questions on that particular specific question, please, right, touch base with me and I'll clarify whatever doubts you have. Yes, Amaya, go ahead.
Yeah, I think two or 3 points I would say. First, in the writ petition 511 of 2020 or 2021, whichever one it was, the Inspector General of Stamps and Registration, who is the main respondent, they have submitted as part of their objections to the writ petition that submission of or registration of deed of declaration in a sub-registrar office does not result in deemed registration of that corresponding association. This has been written in black and white. It's a clear submission by them. It's not an objection. It's a clear submission and admittance by the the government authority. Under such circumstances, if anyone asks you that your association is KOA registered, please be very, very cautious about it. There is nothing called KOA registration. Point number 2. The KOA 1972 does not specify any timeline, any chronology by when the deed of declaration has to be registered. And because of that, some builders, or I would say majority of the builders, they will register it even after executing sale deeds. Few builders will execute it, though, and when I say few, those who are aware of the legal implications, they will execute and register this DOD before the first sale deed. But by then, the builder has practically accepted 100% of the payment from almost all the purchasers. And in spite of this, major fact, the builder falsely claims in the deed of declaration that it is the sole owner of the property. My question is how? He has taken 100% of the payment. He has even sometimes handed you the key handover. Just because the sale deed is not registered, does it mean is he the sole owner at the time of DOD registration? My answer will be no. Because some apartment purchasers may have even taken the benefit of income tax deduction as part of the home loan, which means the home purchaser has effectively stressed his or her ownership to the apartment, and which means the builder is no more the sole owner as he would have claimed in the deed of declaration.
Very good point, sir. Very good point. So coming back to I will take the home buyer side of it. I will not take the expert side of it. I will go by a case study. Probably both of you can answer. There is an apartment by name A, okay, which has been formed in somewhere around 2000 or something, and it fall under KOFA, right? And then AFS is not registered. What is the solution for them? So I will take a case study and I request you guys to answer that. So I know it's been already discussed. So probably we'll go by case so that it becomes easy for people to understand from a home buyer's layman perspective. So apartment is constructed in 2006 or 2007. The builder already sold the entire unit through sale deed. AFS is not registered. Okay. And the builder has got a general power of attorney from the landowner, okay, to execute the sale deed or whatever is the case, right? And then he is out of the context. What is the solution for such apartments?
Shall I go ahead first,
Yeah,
Commander, with your permission?
Please go ahead.
Okay. So first of all, KOFA also kind of brings the landowner into picture to an extent. It does not kind of let the landowner out of the way completely, because your sale deed would have mention of that JDA, joint development agreement. So the landowner cannot say, he is not a party to it. Sorry. Now, as part of this particular case study, the first thing I want to know is there occupancy certificate for the project?
No occupancy certificate.
Then the project straight away comes under RERA.
Okay. So it straight away comes under RERA. The association need to be registered under cooperative society and then ask for transfer of title from the landowner to association. That is the solution.
First of all, ask for compensation, because RERA has the cheating clause. RERA holds promoter accountable. Invoke the powers that RERA has given to individual homeowners. Demand delay compensation from the builder. Why was OC not obtained all this while?
Correct. So OC is one aspect, and on the land title share aspects, so how do we handle?
So assuming that there is OC to the property, I will assume, because then it kind of takes off RERA. Now, when there is OC to the property, the first thing that all the owners should do is get their association registered as a cooperative society. It's a simple application. I think any lawyer can help do it. It costs somewhere around 30 to 40,000, somewhere around that, maybe lesser, depending on the size of the apartment complex. And then once the registration is, or once the association is registered, then the next thing is to approach the registrar of cooperative societies and start to demand conveyance of the title of the project land in favor of this. Because Registrar of Cooperative Societies is the competent authority under KOFA, he cannot say no to this.
Okay. So let us say same case, OC is not obtained. So file a complaint in RERA, ask for a delay compensation plus transfer of title.
Yes. And until then, all the expenditure that has happened from, let's say, the association they also can demand refund of the entire maintenance that has been done so far. Don't be shy to quote, 4 crore, 5 crore amounts. Make it 10 crores and demand for it. There's nothing wrong in demanding it. You can always demand the moon, whether you get it or no, that's up to the authority.
Okay, excellent. So I think I got the point. Pre-RERA, OC obtained, OC not obtained. We got the answer. Now we'll come to, apartment, which has got declared under KOA, Karnataka Apartment Ownership Act 1972, and then pre-RERA. So what is the solution?
I'll take that on.
Yeah, please go ahead, sir.
Look, Karnataka Apartment Ownership Act 72 has nothing to do with the transfer of property or the association.
Okay.
Right? So the answer to that is that the regulatory act is, if it is pre-RERA, it is KOFA.
KOFA.
And KOFA still says that the association should be registered under the Cooperative Society Act or the Companies Act. So the apartment owners should come together, register the association either under these two acts, and ask the builder or the promoter to convey the land. And if not, yes, take up the matter in a legal manner to demand conveyance of the project land to the association of owners.
Okay, excellent. So whether it is pre-RERA or post-RERA, it's a KOA, it's same applicable for
if it is post-RERA, it is RERA applicable.
RERA
if it is pre-RERA, it is
KOFA applicable.
KOFA applicable. See, you are covered under the law. It is just
Correct.
that we have been ignorant of the law and not demanded your fundamental right of owning your property. And that because of our ignorance, that the opposite party has taken advantage and has put us into this particular situation. Now it's time that all of us together wake up and demand, like what Amaya said. Yes, demand the moon. Go to the consumer court and demand for delay compensation. Now, while talking about this, let me bring to you that there is a project called Platinum City in Yeshwantpur, which is now comes probably somewhere very close to the metro station, which is a very old project built by some India builders, etc. Right now, that particular project, a couple of their homeowners managed to invoke RERA because there was no OC. RERA has given a favorable order and told the promoter that register under RERA and various other reliefs which has come. Right? I think Dhananjay, I have shared that order with you. Right?
Yeah,
you can
exactly.
share it with the others. See, we need to see that yes, it is only the crying baby which will get the milk.
Yeah,
we need
Makes
to
sense.
understand that.
Makes sense. And another important aspect is that whether it is a pre-RERA or post-RERA, if OC is not obtained, whether it is any act for that matter, go ahead and register a complaint in RERA. So that's a very good suggestion, Amay sir and Surendra sir. If OC is not obtained, the reason I'm telling you on this platform is in Bangalore, we will see 70% of the building doesn't have a OC. So that's a hard reality as per my understanding. In and around JP Nagar, I can show hundreds of apartments which does not have OC, and builder is either there or doesn't exist, but the landowner exists. So very important point, every homebuyer need to understand the land title still with landowners of the particular project, because AFS is not registered. Though UDI is being declared and registered in sale date, it doesn't convey your land ownership. Very, very important aspects that we discussed so far. Yeah, please go ahead. Let's take up some of the questions.
Dhananjay, I just want to add a little more here.
Yeah.
Right. Gentlemen, please understand one thing, that what happens in most cases is that the landowner is one person and a builder is another person. They come together and get into what is called a joint development agreement. Now, the land doesn't get transferred or conveyed from the owner to this builder. They get into an agreement that I will build, pass on this much to you, etc., etc. All that happens, right? And the landowner gives a power of attorney to this developer to do things on his behalf. Everything, apply for sanction, etc., etc., etc. And even your sale deed, which is conveyance of your property to the individual purchaser, is signed by the developer but not in his capacity, but as a power of attorney holder of the landowner, because
Right.
the law recognizes ownership of land only. Right. So then, in a scenario in what we are in, what happens is a builder will sign the sale deed as a power of attorney holder, and he will walk off. He will take his money. Both of them will share their loot, whatever it is, and the developer vanishes into thin air, whether he's closed his shop or he's bankrupt or whatever happens. Now, over a period of time, right, you have any problem with that particular property, right? Builder is nowhere. He's only a middleman, right? You still have to go to the owner, right? The next thing is that over a period of time, maybe 30, 40, 50 years, when this project becomes due for a redevelopment, right? Then you do not have the title. You are only holding the title for your apartment, right? And when the apartments are demolished for redevelopment, or God forbid, something else happens, like earthquake, flood, etc., then your apartment, which is virtual, is nowhere. Because let us understand one thing: apartment is a temporary structure. Today it is there, tomorrow it is not there. It is land which is permanent. Now, 50 years down the line, especially for a people like me who is almost one leg in the grave, right? My children will not know how to sort it out, because the landowners will say the land belongs to us.
Yeah.
Now, there are two cases in the recent past where such a unfortunate incident has taken place. One is an apartment called Maradu apartment in Kochi, where because of environmental issues, Supreme Court struck down and ordered for demolition of that apartment. Similarly, in the recent past, that is last year, right, another apartment complex called Supertech in Noida got demolished. Right now, these people who paid crores of rupees and bought the apartment is nowhere. So, if at all the land on which the project was built had been conveyed to the owner of the association, association of the owners, at least they could, right, get something out of that land, maybe build again or even sell that land, etc. But if they have not been done, then they're a total loss. Now, should we get into a situation like this? Is something which all of us should ask ourselves and take corrective measures.
Now
Yes,
I got
Dharanjay.
thanks a lot, Surendra. I think now we got a message why whenever there is any cooperative society being formed, why the builders suddenly start shaking, and then why there is a lot of hangama and a lot of trouble that he will try to give. I think we have a live example from Jibin, who's been one of the apartment owner association who created cooperative society acts, and getting into a lot of issues from their side. And we understand what is the reason to it. I think with that note, I will open up the platform. We have some time to for an open discussion. I think Kamaya sir and Commander sir has answered most of the questions, whatever that comes to the minds of the home buyers, pre-RERA, post-RERA, whatever. And now the platform is open. Request everyone who are on the Zoom platform to open up and then ask any questions to our experts on this platform. You need to put on your video so that people will see whom we are talking to. Yeah, thanks a lot. The platform is open now. We can go for it. Open discussion. Please go ahead and ask any questions you have.
So good evening, sir. This is Subramaniam.
Yes, sir. Sir, your video is not on.
Okay. Video because of the what you call that low bandwidth.
Okay.
I'm using the mobile data. Okay.
No problem. Go ahead.
Okay. See, my question is that what is the status of the DOD deed of declaration, wherein all the it's like no difference between the conveyance deed and the deed of declaration. But here, when I check with one of the lawyer, I do not want to name it, what is telling that show me one conveyance deed of any apartment in Bangalore. Like that he is telling, but I am quite confused. Till now, I am thinking that DOD, which is the ultimate document, wherein the rights of the common amenities, everything is transferred to us. So in our apartment case, it's a straight case. Total number of what you call that square feet, divided by the number of apartments is matching with the what we call that area of the land. So I'm quite confused. As of now, I am thinking that deed of declaration is the ultimate document wherein all the details, including the what we call that it's not undivided share, it's the individual share, like that it's mentioned. Okay, in the document DOD.
Can I take that question, Dhananjay?
Yeah, please go ahead, sir. Open to both of you.
Yeah, Mr. Subramaniam, first and
yeah.
foremost thing that we need to understand, the
Mm.
word deed of declaration is a declaration.
Mm.
It is one person or one entity which is declaring, right? For any
Yeah.
transfer to take place, there has to
Mm.
be somebody who is a transferee and a transferor. You get my
Right.
point? I
Yeah, right.
am selling the property to you, so I become the vendor, and
Yeah.
you are purchasing the property, you become the purchaser.
Mm.
Right? Here it is a declaration, right?
Mm.
So the whosoever is submitting this property under the act for a declarer is declaring the facts about the property,
Okay.
right? Which includes all those things which you have said, that plan, etc., etc., etc. Right?
Mm.
Now, I mean, the reason that what you told me, lawyer told you this, I am 100% right, sir. This is exactly what the legal fraternity has done to us.
Okay.
Right? I don't want to say anything more about the legal fraternity. It is known, it is the legal fraternity's profession is to defend my client. Today, the same lawyer will argue for you. Tomorrow, he will argue against you in another client. Right?
Correct, sir.
So it is only opinion. Now, if you want to check the veracity of this particular statement, please file an application for an encumbrance certificate quoting the survey numbers of your property, right? And see for yourself whether the property, like what Dhananjay mentioned earlier, or Amaya mentioned earlier, whereas all the owner's name appear in that encumbrance certificate of the land title.
Yeah,
It will not,
it will not.
right? And just in your case, may I know your DOD is registered under which book?
DOD is with the sub-register office. We are
I know,
registered
but-
under Cooperative Societies Act.
You are registered your property under Cooperative Societies Act.
No, not
No.
the property. Association is registered under Cooperative Societies Act.
Sir, I am
registered-
glad you have crossed 90% of the problem, that you have an association which is registered under Cooperative Societies Act, which means your association is a juristic body which is empowered to hold property.
Yeah.
Right? DOD is not a conveyance. As a matter of fact, Dhananjay, just when he was displaying various documents at the beginning of our session, had put a RTI reply from one of the right. Please, if you go through that, then where it very clearly states that deed of declaration is not a conveyance, right? And please, now since you asked this question, I will go a little deeper into it. Now you will find that the deed of declaration has been registered by different sub-registrars in different books. Some are in book 1, some are in book 4.
Yeah.
Right? And both are wrong, because the act specifies that the sub-registrar is supposed to maintain a separate register for register of apartments and DODs. Right? Now, the writ petition Mr. Dhananjay quoted, which is writ petition 511 of 2021, is basically challenging this issue. Because, see, the government of Karnataka, after legislating this particular act of 1972, just slept over it, did not issue supplementary notifications demanding or instructing departments, various departments, to enforce this particular act and do what is their job. Okay. So, sub-registrar does not know what to do with the deed of declaration, because the deed of declaration finds no mention as a document in the Registration Act of 1908. Right? Yeah. So, these are all too much of legal answers, which I don't want to. So, now
even sorry, sir, even the DOD registration is stopped for some time now.
No, it has not been stopped.
No, not stopped.
It's
not
going
possible.
on.
It's going on, right? So the petitioners in that case of 511, that is the writ petition, asked for a stay in the registering DOD, but the court has not given that
Not
station,
granted.
not granted. But the case is going on, right? The basic plea of the petitioner in this particular case is that since the sub-registrar did not possess powers to register a deed of declaration given to him by the state government, he has overstepped his jurisdiction. So the action of registering the DOD is illegal. So it should be declared null and void. That is the petition.
And what should be the next step for us?
Sir, I would put it this way. You just put those DOD in a cupboard and lock it. Demand transfer of your land, total land, right? As per yours is, I'm sure this must be a pre-RERA case.
Yeah. It's a old apartment.
Yeah, quote KOFA relevant section, right? I mean, I don't want to go open the book and go to the section. Quote relevant section and demand conveyance of the project land from the owner of the land, right, who's the promoter, to your association. You have an association ready hand.
Yeah, correct.
Right? Demand, maybe send him a notice, right? I mean, since, see, the court will say, did you ask him? Because if you go to the court directly, court will say, did you ask him? Did he ever say no to you? So, take this process. Maybe in this case, see, this one, please show this particular KOFA section, whatever section it is, to the lawyer and tell him, I am demanding this. You give me an answer to this.
Okay, right. I will go through it and I will find out. One
Yeah,
advantage is for us is that we are in the good books of the promoter, builder, whoever it is.
Okay,
And
then
the-
excellent, fine.
Please
So
go ahead
we'll talk
and
to
get your connect, do good for the society.
Yeah.
If,
In fact,
if promoter is willing and you already have a platform to take it, I think you're almost there. Like it is, I mean, I don't know, I'm not getting the correct.
We should have more such promoters then.
Yes.
yeah.
No, you.
Luckily, this was his initial project. Unknowingly, he was basically a film financier. Got into this what you call that, tried its foot in real estate. So that's how the project. Even our undivided share is 1:1. If you hold 1,000 square feet of flat, your land, you'll get an individual share of 1,000 square feet.
Have you
Sir,
verified it against the approved plan?
Everything is approved. We got CC, OC, everything, including all the lift also. He has handed over all the original papers, like CEG approval for lifts, because our apartment is 1+2 only, but still everything.
Very
So
good.
Yeah.
that's a good point.
Yes, the mere handover is not going to satisfy it. To get a registered conveyance deed, because you want to be doubly sure that your land title is not with anyone else.
Yeah,
Let me tell you, see, even after submitting the original mother deeds of the project land, there is a provision for the original landowner to say that, he or she has lost the original deed. So they will file FIR. They will kind of say that, this is non-traceable, and they will go for a duplicate.
Yeah.
You will not know of it because you are not the owner. You will not know of it.
Correct, sir. There are some similar cases also like this I have heard.
Yeah.
So, Mr. Subramanian, I suggest that you are one of the lucky guys in this forum. I can see, right? Please go ahead and set an example of taking over project land to the association of owners, which is already a cooperative society. You will be a pioneer in this, because I'm sure Dhananjay will agree with me. We have not been able to find a single case where the project land has got transferred to an association of owners in Karnataka.
Excellent.
Okay,
I think this is one of the
great opportunity.
Great opportunity, Subramanian sir. We'll discuss that offline. I know the project very well. My students also stays there, so we will work together on this.
Yeah. Okay. Thank you, sir.
Okay. Very good. Any other questions? I know since we are bringing up this open discussion, any others want to have question? Please go ahead and ask, sir. Abhishek, you have some questions?
Yeah. This is Abhishek. I'm a colleague of Jivin, like having a friend of mine as a board member in the same society. right? We are going through some challenges, and there are a few questions actually with respect to that. So we have received partial OC. So this is something which we don't know, whether we have got a correct kind of document, or is it some kind of fluke that has happened to us. So if you can kind of give some light on that, whether partial OC is equal to OC, or is it something which we should kind of look into?
Very good question.
Because
Very good question.
many people are actually staying here. Almost 5 of the towers, almost 60 to 70% people are staying.
Can I
Please
take
go ahead,
that?
Umesh, sir.
Yes, okay. So there are two judgments that I know of. First is the judgment of, I think, Justice Ravi Mallimath back in 2012. I don't remember the writ petition. It starts with 1-1 and it ends with 5-5. I don't know the middle number. That is one. That was in 2012, where he clearly has it written in black and white that partial OC is illegal as far as BBMP bylaws are concerned. BBMP bylaw 5.7, I think, it says that partial OC can be given by the municipality only under exceptional cases, and that too to select floors in a building. If this is the case, how do you explain partial OC to the entire building?
Amaya, I'll just, sorry to interrupt you. That is partial occupancy. That is, in a building, you occupy that building in a part. That's partial.
Correct.
Not
Correct.
partial OC. Partial OC is a certificate. I mean,
That is
OC
anyway
a
not there.
No, it's not there. So, no.
It's not there.
No, see, this is again twisting the words, right? Because of your ignorance. So, partial occupancy in a building is permitted by the BBMP, right? Under circumstances, but partial occupancy certificate cannot be given.
Cannot be given. Correct. So that was first judgment. Second judgment is, I think, of the High Court of Karnataka only, against Messrs. Total Environment versus Stephen Verghese, I believe. And over there, first it was the RERA authority which ruled that partial OC cannot be accepted. The Real Estate Appellate Tribunal also ruled likewise, saying that partial OC is illegal. And High Court of Karnataka also upheld the same judgment. It said partial OC is illegal, clear. Right now, the matter is in Supreme Court. I think it's going to be decided sometime this week, most likely on 8th or 9th. And if we are all lucky, that judgment will look at the illegality of partial OC across not only Karnataka, but across the entire country also.
Okay. So if they are collecting all the maintenance and everything, so that is illegal. That is what we understand. They are doing it for almost
Absolutely. And there is NCDRC judgment where it said no OC, no maintenance. And yes, everybody is aware of that. I think it is some Koshi or some VDB, some one of the VDB properties in Whitefield out here. There it is clearly stated. Then there is one more judgment of Supreme Court, wherein the petitioner was a cooperative society from Maharashtra, and they filed NCDRC complaint and said that for a refund of maintenance. Supreme Court upheld it. Supreme Court said because there is no OC to the property, partial OC is illegal. So refund the maintenance amount collected all this while.
Okay. So I think the next step will be one to wait for the Supreme Court judgment, and maybe second is to go for a consumer forum, right, to file a case.
Absolutely, you can, because then you all signed up for occupancy certificate with power connection, BWSSB water connection, CEIG approvals, everything. Without approving all this, you have been handed over something which is incomplete. Why should you settle for something for which you have paid through the nose? Your life savings have been paid there. Why should you settle for something less than that?
Right. So just a question coming.
I'll just
Yeah, go ahead.
interrupt, Mr. Abhishek.
Mhm.
Your project is the classic landmark. Am I right?
Yes, correct.
Gibbons, right? Now, from what little that I've understood is that it's a large project, right? The sanction plans is a single sanction plan for all the towers, etc., 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 wherein he has completed some and is yet to complete others.
Right.
Now, this issue of OC, if the sanction is, because this is again how the industry and the bureaucracy is, glossing over it all hand in glove, is that, right? If the sanction plan is phase wise, right? I take a separate sanction for phase one and complete it, then I get a OC for phase one, right? But if I show in a single sanction plan, right, then because it is going to take that much more time to complete the subsequent phases, but the first two towers are ready, he wants the money, right? So this tamasha of partial OC is resorted to, and the BBMP with with what we know will give them a partial OC, but they are not under liability because they said we have done this, we have done that. It is you who is staying there who is at risk, right? So first check whether the plan which is for the complete project is a single plan and it's a single sanction plan, right? Then until he completes the complete all the phases or whatever is there in the sanction plan, right? Only then he will be eligible to get an OC. Till then he will, what you call, keep giving partial OC and cheating others.
See, one thing that we should know is maintaining a property is a difficult task. It involves money. Builder doesn't want to spend from his kitty. That is why all these gimmicks of partial OC and some phase wise and all these things are coming. Don't fall for it. Ask BBMP, ask the joint director town planning regarding the the legality of partial OC.
Got it. Thank you. And second question, I kind of asked you, and I think Kamya sir, you replied to that as well. But the question is, we few people have joined hands to form the cooperative society, right? There are others who do not want to, and they are creating a confusion that UDS will be transferred to the cooperative society. We will be losing our rights to it. So why should we kind of join the cooperative society? We should go under any other thing, or maybe we should not join it altogether. So what is the resolution to that? Like how should we deal with this?
I think I've answered that in the chat.
Okay, let me reiterate that. Abhishek, I think most of you can go and check your AFS. AFS is not registered. You are not a owner of the land. It is just illusionary world home buyers are living with an assumption that sale deed mentions the UDI or UDS some number is a convenience of the land title. As per my knowledge, please go and check your AFS may not be registered. That means you're not a land owner within that title itself. So there is no question of losing. You don't even a owner, question of losing comes if you are a owner, right? So it's very important that home buyers understand this concept of illusionary world and get out of it. You are on the right track. You already formed a cooperative society. Please educate all other home buyers. Feel free to share this video, question and answer session, and ask them to understand. And this is a public platform, and we can challenge anyone on this forum saying that what we are saying is as per our understanding. We can sit in front of the government, we can sit in front of the policy makers to debate on this subject. This is an open challenge to the government also to make us party in the policy making. We will show what is the policies. Yeah.
Mr. Abhishek, just 1 second, Mr. Abhishek, those who claim that they will lose their UDS or whatever it is, right? Please ask them to file an RTI application to the sub-registrar where your sale deed is registered, and ask him to give them a copy of the EC where that is the land EC.
Project title, not your flat.
Project title, not your flat, right? Where this will reflect transaction of 100 square feet, 200 square feet from the total land of 10 acres or whatever it is in the name of so-and-so. right? Only then a encumbrance is created. That means a land is taking place. Let them get an answer before that, right?
And
Because
another important, straightforward, even splitting is not required. You please take a EC of your project title as of today. If your sale deed is done 5 years back, then your UDI or UDS, some number 400 square feet should have reflected in that, right? So it will not, because your AFS is not registered. Very, very intelligently and very, very, because of home buyer's ignorance, it has been carried away for years together. And at least this has to stop. This has to stop. The only way is register a cooperative society and ask for transfer of title. And I think one important question that will arise, sir, on the transfer of title, I think there is a stamp duty that need to be paid. If the title of the property, all the, combined together forms the entire project land, then probably we have to sit together with register of stamp duty. It's already being paid. Then transfer becomes easy. Probably it's Commander or Ameya, sir, you want to touch base on the stamp duty for transfer for such lands?
I would just kind of give 2 or 3 line answer. Commander will have some details there. So since all of the apartment purchasers are collectively own the project land, and if everybody has executed sale deed, which means the sum of the UDIs of all the apartment owners should be equal to the total physical area of the project land. If that is not the case, that means if the total happens to be more than the physical area of the land, that means builder has done extra constructions and there is a serious fraud involved there. It's a criminal in that case.
If it is less?
If it is less, you are good. If it is less, you are good. But then builder has done some TDR, the transfer of development rights, somewhere else. That also you should demand from the builder because you have encumbrance on the property.
Right, right. I will give you an example, sir. I think very good example. In one of the project in JP Nagar, the land area is 18,000 square feet, whereas the UDI conveyed to individual owners is around 13 or 14,000. There are around 4,000 or 5,000 UDI still missing, and there is one additional floor. There is one extra floor which has been constructed by the builder, and 4 flats has been sold. And they also have got a UDI registered, some portion of it, right?
It's a fraud.
It's a fraud.
So in this case, what I mentioned to you about the Platinum City in Yeshwantpur is a typical case, right? I mean, that is a little more distinct. From what I know, I may be a little wrong here and there. The UDS given to the number of owners who are already existing is exceeding the UDS, but exceeding the sanctioned plan of other towers, etc., which are yet to come up. Right. So all this is there in that particular order. I think is very clear. So as a matter of fact, I think RERA has put a stay on that particular developer to go ahead with any more construction or selling any more apartment because he's already over. See, this is the cheating that the developer, the promoter is doing as far as UDS and UDI is concerned, because none of us know what it is. Well, talking about UDI, it is a common what you call practice in the current day situation is that the developer is telling all of us that the UDI is only restricted to the plinth of your tower.
No.
Ameya, Dhananjay and me, we are a party to it now in our project of Mantri Serenity. We have approached the consumer court with this particular issue and we will get an answer to it. Right? This is what it is. So, you see, because as a matter of fact, let me now share with you people that the builder, Mantri Serenity, the developer, has even today registering sale deeds without indicating the quantity of UDS, he calls it. There is blank. Neither is it
Zero.
in percentages, nor is it in square foot. And
absolute zero.
We have been telling our home buyers, please don't go and register your sale deed without this, but then people are still doing it. So you see, this is the reality of the whole situation.
Ground reality. Got it. So just one last question, like anywhere, like any portal is there where we can check, like, what is the encumbrance of our land or the entire society,
Bhumi.
or, like
Bhumi.
Bhumi records. Okay.
Bhumi is a platform where you can check.
Okay.
See
Got it.
this
Thank you.
this UDS and conveyance and stamp duty etc. which just now we came into all this thing. Just now we've had this Mr. Subramaniam sharing his what you call, I would say he is in the pole position. I mean, I would put it this way, that his builder is ready to give him the land. They have a society which is ready to take over. Right. This will be an ideal case to find out how this whole process is done. Right. Like he said, they have already got the complete land put into their UDS, which means that when their sale deeds were registered, the component of land has also been taken care of as far as the stamp duty is concerned, right? As a layman, from what I understand is, if there are 10 apartments and all of them have paid stamp duty on the component of land which is there in their sale deed, right? When you cumulative it, if it comes to the total land that is being passed on to the association of owners, then there should be no reason to ask for stamp duty. If there is a shortfall, yes, you will have to make it up. Right? I am studying in this case, trying to get some information from the state of Maharashtra, because we don't have a template, nor do we have a precedence here. Right? So Mr. Subramaniam's case will become a precedence. I would put it this way: I am ready to run around with Mr. Subramaniam to see that this case is done. Because once I get one precedence, then it can be it will open the everybody else.
We will try, sir. We will try 100%. And further, our case got what you call that further confirmation. 3 years back we got a Kaveri connection. There also the same square foot got matched. Accordingly, we have paid the betterment charges. We are getting Kaveri twice a week or thrice a week. So this is the
Mr. Subramaniam, I wish you all the luck and Godspeed. Please, right, without hesitating, go ahead and take the next move.
Okay.
Betterment charges are to be paid by the builder. So get your refund from him.
Yeah. Okay. We will try.
Okay. Okay. I think with that last question, we are running out of time. I think 2 hours of discussion. I wanted to bring everyone on this platform, is that this is just a beginning. That's why you will see the number 1 on this particular platform. It is a number 1 means this is the first session. So we are planning to have these continuous sessions for next couple of months, so that we wanted to reach maximum home buyers as much as possible, and also the policy makers. These videos will be shared across to the policy makers in Karnataka. These videos will be shared across all the social media. These videos will be shared to all the presses and as well as important personals who are working on this particular platform, to make sure that we have a proper structure in place. And some of the suggestions and recommendations given by Ameya sir and Commander sir are well received. And then please go ahead and fight for your land rights, because we are all living in an illusionary world. And before we close the session, I wanted to run through some of the important recommendations that we have given to the government. So please let me know if this is visible. Is it visible?
Yeah, visible.
Yeah.
Okay. So I think whatever the request that we are given, I'm just running through. This has been submitted to the policy makers. So we requested the policy makers to pass an order to concerned department and instruct the Inspector General of Stamps and Registration to notify registration of Association of Authorities as a body corporate under Karnataka Co-Operative Societies Act 1959 or as Section 8 of Companies Act 2013. This is as of now notified in state like Maharashtra and Gujarat, and in conformity with local law of KOFA, right? And the second recommendation that we have given to the government is pass an order to stop the practice of promoters claiming deemed registration of an association under KOA 1972 through practice of registering deeds of declaration with bylaws of deemed association. And the third recommendation that we have given is pass an order to register of cooperative societies to issue notification to ensure all apartment associations are registered as a cooperative society under Karnataka Co-Operative Societies Act 1959. If the builder is untraceable or unwilling to participate in conveyance, the home buyers could apply for a register for deemed conveyance. And the fourth point that we have passed on to government is pass an order to Register of Cooperative Societies to bring in the required changes in the Act to permit time-bound conveyance and the builder promoter transferring the project title to association as per RERA or KOFA. If the builder promoter doesn't execute conveyance deed, association of owners must be allowed to take over the project schedule land for which the builder would have taken for approval through a system of deemed conveyance, which is in practice in Maharashtra. And the fifth recommendation that we given to the government is pass an order to permit registration of cooperative housing society to enable migration of deemed associations under KOA and those registered under Karnataka Society Registration Act 1960 to the Karnataka Co-Operative Societies Act 1959 with a modification as essential in their bylaws, memorandum, and to define the shares for the members of the association. This is a very important stuff because majority of the apartment associations, either they have a registration under 1960 or declared as an association under KOA. So we are asking for deemed declaration of this two Cooperative Societies Act with the smaller modifications in the Act. So request the government from KHBF is 6th point is direct the Register of Cooperative Societies to follow up on interdepartmental coordination to rationalize the stamp duty payable as stamp duty already realized from existing owners and collected if not realized from the authorities as prelude to membership and admission to cooperative housing society. This is what Ameya and commanders just explained about the stamp duty. And the last point is on direct the RERA authority to ensure while giving RERA registration number to developer, the association of authorities to be written to be formed under Cooperative Societies Act 1959. If this mandate is being followed in RERA, then most of the cheating will stop because while giving RERA registration itself, if this is being followed and ensure the real estate regulations will fall into place. And some of the references, you can also look into it for your own reading, for your personal knowledge, is Karnataka Real Estate Regulation Act, RERA 2016, and the Transfer of Property Act 82, Karnataka Stamps and Registration Manual, and Registration Act, and the Karnataka Mahanagarapalika Building Development Act. We call it as bylaw where you understand what is FAR and other stuff, right? And thanks a lot. Wonderful session. Very good audience with very good questions. And special thanks to our Colonel Commander Surendra sir and Ameya sir for sharing your knowledge. And this session will continue. And a last note from Ameya or Commander sir. I think Commander sir, since it's a Navy day, Ameya sir, you want to pass on one message, and then Commander sir, and then we'll close the session.
Okay, my simple message is, after having paid, your life savings, please don't settle anything less than that. Stand up, put up your grievance across the various authorities. As Supreme Court has ruled, you can file concurrent remediation in RERA as well as in Consumer Forum. So get your rights. Don't be shy of asking double the amount of compensation than what you have paid. Let the authorities say why you are not getting it. If you are not satisfied with the authority, please also leverage Lok Ayukta. They now have execution powers. That's all.
Excellent. Thank you, sir. Commander sir, Navy Day today. Please, one message.
Yeah, my only humble request to all my co-home buyers is, this is a long struggle, and there are more enemies than friends in this, apart from those who are the home buyers, right? So all that you need is patience and perseverance, right? You will meet setbacks in various offices, courts, etc., 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 but don't lose heart, right? Here is a group of home buyers who are spending time and effort to study the case and move forward, right? Please be a part of it. If we remain united, only then can we win this battle. I am told on a regular basis from my friends, relatives, and old ex-naval colleagues, and even of course other service colleagues, as to why are you doing this? You're already 74, 1 foot already in the grave. Why can't you just relax? Why are you doing this on a daily basis? So I tell them that this is my passion. So I am continuing to do this because that, yes, I am blessed because I don't have to look for where then my next meal is coming, because God has taken care of that, and I have time in my hand, and my only aim and objective is that I do not want to leave any
Liabilities.
stress liabilities to my children. So please, right? Please, we are here, and I mean, I am not very tech savvy like my good friend Amaya, right? So answers questions, quickly as and when you keep asking. So please bear with me. You're most welcome to call me up and ask whatever questions or clarification that you need, and I'll be more than happy to oblige. Thank you,
Thanks a lot.
gentlemen.
Thanks a lot,
Good night.
Commander sir, and thanks a lot, Amaya sir. And a last note from me: please share this knowledge, because the reason why we are here is to share the knowledge, so that whatever we gained through our last couple of years of struggle or fight, the other party should get benefit. So our next generation should get benefit. That's the only way we can fight in this battle, because this is a long journey. The Karnataka Home Buyers Forum is all over in the social media. Facebook, we have a page. Twitter, we have a handle. And YouTube, we have a channel. So request everyone to utilize this social media presence, and please share it in your personal profile, so that your friends, your family members who are going to purchase a flat will insist on registration of AFS. One step of registering an AFS will save a lot of trouble for the home buyers. Please always remember this. Registration of AFS is the key to success for the entire strategy that we are putting across for the new set of home buyers. For the existing ones, cooperative society formation is a solution immediately. For the rest of the home buyers, please ensure AFS is registered and then form an association of cooperative society later, right? So with that note, I will conclude the session. Thanks a lot to everyone, Amaya sir and Commander sir, for the wonderful session and the knowledge that you have shared with all of us. And very good audience from Subramaniam and from people from Classic Apartment. Sorry, I forgot the name, sir. Abhishek, yeah, Abhishek. And thanks a lot for the questions that has been populated in the chat as well. And please share this knowledge to your home buyers community to spread the knowledge. And we are ready to sit in front of the policy makers as well. And if any cooperative society department wants to sit together to draft this policy in the interest of the home buyers, we are ready to accept the discussion. And then we'll be more than happy to spend time on with the policy makers to work on this. So with that note, we are closing for today, and have a wonderful Sunday. And tomorrow is starting. Let's all of us work from Monday to Friday for whatever we are doing, and rest of the team can enjoy your holiday or whatever. And then let's go and enjoy the Sunday. Thanks a lot. Wonderful day. Thank you all.
Bye-bye. Thank you, Namaste.